All right, well, let's go ahead and get started. We'll let people keep filing in. Thank you for joining us this evening. I'm Julie Barrett. I'm the founder of Conservative Ladies of Washington, and we are going to do a legislative 2A update for you this evening. I know a lot of you who are here tonight, probably all of you, have been following along pretty closely what's been going on in Olympia this session with these gun bills and a lot of other bad legislation. And I'm excited tonight. We are joined by Jim Walsh, who is one of our fearless fighters in Olympia. And he is doing amazing work. And I'm always in awe of how tireless he is and how he manages to stay sane in Olympia during this crazy session. So thank you, Jim, for all your hard work for Washington State. And thank you for making time to do this tonight.
Oh, of course. This is fun. This is the fun part.
This is the fun part, I bet. And also joining us tonight is William Kirk, aka Bill of Washington Gun Law. Bill and I have been working side by side throughout this session, geeking out together, probably a little more than is healthy. But we are trying to do our best to tag team together and keep you guys up to date on everything that's going on. So we're going to do our best to take a lot of questions tonight from you guys. We all, the three of us, Jim, myself, and Bill, we all get a lot of questions from you guys about these different bills and what's going on and what's going to happen next. And so we want to dedicate most of our evening here to your questions. But I want to kick us off with Representative Walsh and give Jim a chance to give us an update. What's been going on, where we're at now, and where we're headed. So, Jim, I'm going to hand it over to you.
Sure. Thanks, Julie. We're about a little more than halfway through the current legislative session in Olympia. Remember, the legislature in the state of Washington is not a year-round. It's not a full year-round legislature. We go about 5 months in the early part of the year, start in January and go to usually sometime in May. Sometimes it goes a little longer if we don't finish all of our business. And so we're at about the halfway point, a little more right now. And we started the session out with the governor and the state attorney general very full of themselves and pushing a very aggressive anti-gun rights agenda that was comprised of about a dozen bills spread about evenly between the state house and the state senate that restricted and impaired and infringed your gun rights in various ways. Through the early committee hearing process, the usual back and forth and narrowing down of the hundreds and hundreds of bad bills that are filed every session. Basically, we pared it down to 3 bills that restrict and impair and infringe your gun rights, each in pretty bad ways. Probably the most high profile, the most controversial is House Bill 1240. And that is a so-called assault weapon ban. It is structured somewhat similarly to the federal assault weapon ban of a couple of decades ago that was tried for a short time at the federal level and ultimately abandoned. There are a few distinctive parts of the assault weapon ban here in Washington that we're considering. It is not restricted to semi-automatic rifles of a certain caliber and a certain projectile speed, as most such stuff is. It bans and restricts the sale of a number of types of firearms, not just semi-automatic rifles, but also some shotguns and also some pistols. So it's very broad in terms of what it tries to restrict. It puts a fig leaf over, or tries to put a fig leaf over some of its constitutional problems by focusing on transactions. and saying that what is actually banned are the sale of these sorts of firearms going forward. So it does not try to make illegal the possession or ownership of these sorts of firearms if you have them already. People say, well, am I grandfathered in? Grandfathered is not quite right, technically the right term to use, but for the sake of argument, yes, you're grandfathered in with anything you have currently. Trouble is, you can't sell or even give away restricted firearms that you have currently to anyone else. And it is it does restrict and ban the sale of these types of firearm going forward. That's bad bill number 1 of 3. Bad bill number 2 of 3 is House Bill 1143, which is a broader bill. It's not quite an omnibus bill, but it covers a lot of ground. What it started out trying to do was creating a new permit, that it would have created a new permit in addition to a concealed pistol license that any Washingtonian would need to have in order to buy or sell any firearm. We were able, in our debates and negotiations, to get rid of the permit piece of 1143, but there are still troubling elements of it remaining. It requires you to take a firearms safety course at least once every 5 years and keep proof that you've taken the course in order to buy or sell any firearm. It also creates or really expands on a database kept by the state's Department of Licensing that is essentially a gun registry and a gun owner registry. So we don't like it for that reason too. The whole idea in 1143 that you have to take a class before exercising a constitutional right makes the whole bill suspect. But they did get rid of the permit piece. So there's not a permit requirement anymore, but there is still the training course required. And then the third of the 3 bad anti-gun bills is a Senate bill, started out in the state Senate, Senate Bill 50. This is a bad one. This bill basically lowers the standard for suing a gun manufacturer or a gun distributor or a gun retailer, a gun dealer, if any firearm that they touched anywhere along the manufacture, distribution, and sale process is used badly, is used in a crime or illegally in another way, you can sue the makers. Again, it concentrates a lot of the enforcement and the suing authority on the state attorney general, who, as we know, and all of us who live here in Washington, loves to sue people and loves to issue press releases about suing people. He doesn't win as many lawsuits as he'd like to think, but boy, he files them. So it puts most of the enforcement in his hands. There was, in the original draft of the Senate bill, what is called a private right of action, which means anyone could sue a gun maker or a dealer. That was taken out. We were able to get that stricken out of the Senate version, the Senate bill that came across the floor in the Senate. So currently there is not a private right of lawsuit in it, but the state attorney general can sue until his heart's content. There is some talk that some of the anti-gun radicals in Olympia are going to try to reinsert the private right of action into the bill as it is heard and debated in the House. But that hasn't happened yet. So those are the 3 big bad bills. All 3 of them, I believe, are unconstitutional, each in their own ways. Remember, the Washington State Constitution, in many ways, is stronger than the federal Constitution in terms of describing your right to keep and bear arms in defense of yourself and the state. But the federal government's Constitution is pretty good too. And sort of hanging over all three of these graspy little bills, these unconstitutional little insults, is some recent action by the US Supreme Court, particularly in its Bruin decision out of New York State, that really makes it clear that these sorts of state laws are unconstitutional and likely to be reversed by a federal court. But at this point, I think I'll hand the ball over to Bill Kirk, who can talk a little bit more about some of those aspects of the constitutional defects in these three bills.
Well, thanks, Jim. And just real quick before I launch into my stuff, for those of you who don't geek out on this legislative stuff all the time, like Julie Barrett and I do, there is nobody in Olympia fighting harder for your Second Amendment rights. And I mean this. You can go down, watch the videotapes yourself, watch the replays, but Representative Jim Walsh is absolutely fighting like holy hell for all of you folks. So kudos to you, Representative Walsh. I've been very impressed with your efforts this year. Last year, too, you're fantastic. So a couple of things I wanted to add about some of the things. On 1240, there is a grandfathering provision, and if you read the language, there is a possibility that your children may get to keep the firearm, but there is an impossibility that your grandchildren get to keep the firearm, and that will ultimately constitute an unconstitutional taking, violative of the Fifth Amendment. It's just a generation down the chain from what we normally see it. 1143, kudos to the people who did plug away at 1143, because this bill has been gutted. It's still a bad piece of legislation, but it's now a bad piece of legislation. It started as a horrible piece of legislation. So that's really good. And then on Senate Bill 5078, a similar bill like that was passed in New Jersey a few years ago and struck down. And I think we all can agree that New Jersey is not a particularly 2A friendly state. So you can understand where that's coming from. What Representative Walsh was talking about is that there was a landmark decision in June from the United States Supreme Court. There'd been great debate over a number of different circuit courts about what is the proper analysis when we're taking a look at the constitutionality of gun control regulation. And the question that had been asked of lawyers like me all the time is, how do they get away with this? How is that law still constitutional? How do they get away with that? And the answer is that they had this two-part balancing test where the court could acknowledge that it was an infringement of the individual's right, but they could weigh that infringement against the greater need to society to have these small infringements for the greater good. And there had been Justice Scalia back in the day had said this test was wrong, it's completely wrong, and had urged for it to be a one-part test. What Bruin finally did in addressing some of New York's ridiculous concealed carry laws is said, listen, that two-part test is very cute, but it's one step too many. And so the current state of the law is that we take a look at the text and the history. And what I mean by that is if the text of the Second Amendment covers the activity that is being restricted, it is presumed to be unconstitutional. And the only way it will be deemed constitutional is if you can find some sort of historical analog going back to the late 1700s that would justify it. Since we don't have any analogs like this to justify some of these bans, what these laws will be analyzed will be under what's called the common use test. Not developed in Bruin, reaffirmed in Bruin, but developed in Heller. And the common use test says that when we go back in history, there's only one historical analog that we can find, and that's that we do permit the regulation of dangerous and unusual firearms, not dangerous or unusual, but dangerous and unusual. And since we're talking about the most common sporting rifle known to man, used for many, many lawful purposes, self-defense just being one of them, there is nothing unusual about this firearm. And that's why these laws ultimately will fail under the appropriate constitutional standard.
You caught me off guard there. That
You think I was going to keep
done?
I get right to it. Let's go.
Thank you, Bill. You always, I'm always in awe of how you just rattle this stuff off the tip of your tongue like that. It's always fascinating to me. One thing that, and I don't want to spend a lot of time on this, but Jim, I know that you hit on the big three that we actually whittled down from what felt like a dozen gun control bills when we started this session. So that's sort of a small win, I guess. But there are a lot of other bills that do address gun rights that people maybe aren't as aware of. So I just want to make that note that we are tracking those, such as Senate Bill 5006 and House Bill 1562 that kind of take a different angle of chipping away at the Second Amendment that just aren't getting as much airtime as some of these other bigger ones. Do you want to spend just a couple minutes chatting about those?
Sure. Senate Bill 5006 is probably the one that is more interesting of those other bills. In this state, we have a system by which an individual can voluntarily surrender his or her Article 1, Section 24 or Second Amendment rights. That is, they can voluntarily put themselves on a list of people who are prohibited from having guns, from keeping and bearing arms. It was pitched a few years ago as basically a suicide prevention effort. And I've had trouble with it. A lot of us who actually follow the Constitution have had trouble with it since it was launched. What 5006 does is it expands and makes easier the process of putting yourself on this identified restricted list. And then it does some things that are really bad. It actually makes it a crime if you possess a firearm after putting yourself on this list. One of the things that the supporters of it promised when they first proposed this waiver of rights was that they would never criminalize violating. It was done just out of concern for a depressed or suicidal person's suicidal tendencies, and that it was more of a mental health issue than a constitutional or certainly a criminal punishing issue. But this bill incrementally basically backs off that promise, and so it does become a offense if you put yourself on the list and then are found to have guns. There are other problems in it. It does away with some kind of procedural requirements to put yourself on the self-restricted list, making it easier to get on and maybe a little harder to get off the self-restricted list. So that's one worth watching. It is not front and center as the big three are. And there are a couple of the other bills out there. One which has to do with the restoration of firearms rights, how an individual, usually who's been convicted of a crime in Washington, they lose their right to keep and bear arms while they're in prison and after, while they're paying restitution and making other atonements for their crimes. But there is a process in the state where that individual can get his or her firearms rights back. And one of these proposals makes that restoration of rights process more difficult and not as likely to happen for a person who's trying to restore their rights. Sometimes you'll lose your rights too because of mental health problems, even if you're not a criminal. And the restoration part is basically the same. So for someone who's lost their firearms rights, restoration is important. I'll point out as well that as some of our colleagues on the left have pointed out a lot, there are racial elements to the criminal justice system. There are racial elements to the prison system. Restoring rights to keep and bear arms is of particular importance to people in racial minority communities. If you've been to jail and you pay your your debt to society and you are living a better life and you're law-abiding, you ought to be able to restore your rights to keep and bear arms. And if you can't, the inability to get that right back cuts against racial minorities, and that's a bad thing. For every reason we've heard criticisms of the justice system and criticisms of the prison system, there should be criticisms of keeping these people's rights to keep and bear arms restricted. So, but these really, Julie, these are some smaller and more technical things. The big three are the so-called assault weapon ban, this test to exercise your constitutional right, or course to exercise your constitutional right, and then this gambit to let the state attorney general sue any gun maker for anything. So those are the big three.
Yeah. Thank you. I just wanted to let people know that there are other weird little things kind of, I see the legislation as a web, and a lot of these bills are interconnected. And so I'm always kind of trying to connect the dots. So thank you for indulging me there and letting everybody know what those are about. Bill, did you have anything to add to that?
Oh, they're all bad bills. That's all I just want to add to that. Okay. They're all bad.
Okay.
Actually, the one thing we're concerned about on 1562, which is the restoration thing, is that they're tracking changes to 941.040, which is unlawful possession of a firearm, to also include the attempt to possess a firearm. Now, that's kind of contrary to common sense, that you could be busted for unlawful possession by attempting to possess something, but only the Democrats could think of that. But the reality of the situation is that some people hire attorneys to do restoration work that, I don't know, really don't do the work as thoroughly as they should. And so they'll have paperwork that appears that they're restored. They go to buy a gun. You can talk to any NFFL. This happens all the time. And they get denied. And they get denied because they, in good faith, believe they've been restored, but their attorneys neglected to do something. Under that proposal, that suddenly becomes felonious activity. I just don't see the purpose of that.
Thank you. Perfect. So let's, how about we dive into some questions? All right. We've got a lot coming in. So everybody use that Q&A function to submit your questions. And we've got Eric fielding the questions for us, and then I'll pitch them over to Jim and Bill. So Shannon is one of our CLW members, and she's asking, what do these changes mean as I look to carry a gun and get my CPL?
Shannon, if you want to get a concealed pistol license, these changes have no bearing on that whatsoever. I highly encourage any lawful and responsible gun owner, if you don't want to be a daily carrier, to at least get a concealed pistol license so that you have that option. The types of firearms that you're most likely going to be carrying concealed, almost all of them are not affected by House Bill 1240. So I don't think that this has any bearing on that. And I will say candidly, and we don't want to get too loud about this, right, Representative Walsh, because they'll try to change the law, but I think Washington State has actually a pretty fair licensing regime when it comes to concealed carry licenses, as far as being a shall issue state and doing so in a pretty time efficient manner. So I would just encourage you, no matter what the craziness is in Olympia, go out and get your CPL.
It's always valuable to have a concealed pistol license in this state. They're trying, the other side are trying to take away some of the advantages of having a CPL, but at current, it's a good process. And Bill's right, you can usually get them turned around fairly quickly. You do it through your local law enforcement office, depending where you live, a sheriff's office or a local police department. And it's a process. You have to fill out the application, you have to pay a fee. You'll get fingerprinted, all 10 fingers, and then they do a background check. So it's pretty thorough. Probably worth noting while we're on the subject, we are in the midst of rejiggering how we do background checks in the state. We have, as most states have, relied on the FBI and their NICS system to do our background checks. FBI is basically getting out of the background check business. And each state is handling that in different ways. Here in Washington, we are shifting our background process to the Washington State Patrol. The State Patrol will handle background checks, and that's neither a good nor bad thing. That's kind of a neutral thing. In some ways, it's better. There are some gun rights people who actually prefer it. They think it'll make for a quicker and hopefully more efficient process. But that is in the process of happening. This very moment, we're still using the FBI NICS system, but over the next, about 12 months, maybe 15 months, we're going to be shifting over to the State Patrol.
So interesting, fun, quick fact. At the end of 2019, I think there was some stuff going on a federal level. I didn't even own a firearm yet. My husband did. And I decided to get my CPL because I just was seeing the writing on the wall, and I got lucky and I got it all done right before COVID happened. And anyway, we don't own any guns now. We lost them all in the boating accident. So Robin is asking. Robin is over in Spokane. She's one of our members, and she is owner of Sharpshooter.
Oh yeah,
Sharp
I've
Shooting.
been there many a times. It's a great place, Spokane Valley.
That's right. So Robin says, tell me how this impacts consumers who are in the waiting period for approval of a suppressor now that you won't be able to add a threaded barrel handgun under HB 1240.
Unclear. It will certainly not make it easier. The language in 1240, which describes threaded barreled firearms, is one of the problems in 1240. It's poorly drafted. For the moment, the letter of the bill, if it becomes law, would seem to restrict your ability to get a suppressor, but it's not clear. And certainly the intent of the bill is to prevent that from happening, but it's so poorly drafted, I'm not sure it would do that. And so I assume someone's going to try to proceed with that transaction and see if anybody's willing to try to enforce this poorly drafted law that will no doubt be in the courts almost immediately. You might want to check with your sheriff and see what their opinion about this is, and whether they would try to enforce that or not. And as a federally licensed dealer, you may want to proceed carefully because you don't want to jam up your federal license. But I don't know, Bill, you can probably.
Yeah, no, I've actually tackled this issue, and I actually took 3 phone calls from various FFLs, Robin. So I'm actually glad you're asking this. As I read, and I'm looking at it right here, the problem that Representative Walsh is talking about is that one of the things that's defined now as an assault weapon is a semi-automatic pistol that has the capacity to accept a detachable magazine and has any one or more of the following. And then there is right here a threaded barrel. The way I read this is that if you have people who are interested in Form 1ing or Form 4ing a suppressor right now, I don't see anything in here that prohibits that whatsoever. Washington law is very clear. You can have a suppressor so long as you comply with all appropriate federal channels. What you want to get right this second, however, is the barrel that you're going to need for that particular firearm. Because I do believe that when you take a look at the parts restriction on House Bill 1240, there's a question whether or not threaded barrels would even be available for sale anymore in the state of Washington. So I think that as long as they have the threaded barrel, whether you have a Form 1 or a Form 4 in the hopper right now, I still think that they'll be able to get it and use it. They just need to have the appropriate attachments now.
Yeah, that Bill brings up a good point. That section of 1240 that talks about parts, what it was, I believe, is whoever drafted it was trying to address lowers. You know, the part of a semi-automatic rifle that
constitutes the firearm
is the firearm, is
right.
The gun.
Yeah.
So, and they know that hobbyists, enthusiasts, gun people like to buy lowers and basically customize their own system out of the lower. So I think what they were getting at was trying to restrict lowers, but they wrote it so badly it could apply to any part of a firearm. And I don't believe that was the intent of the drafters, but they're so ignorant of how guns work, it's hard to tell what they meant.
That is true.
Thank you, gentlemen. All right, this next question comes from Leslie. Also, Leslie is on our legislative action team. She's one of our team leads, and she's asking, this is probably a question more for Jim, because Bill and I are probably wondering the same thing. In light of Bruin, why do we not see legislators push back in committee to require the historical precedent in the bill?
Well, first of all, we do. We just we're outnumbered, so those attempts at a amendment or motion get shot down. Generally, and people, I get a version of this question too. You know, why can't legislators who put forward unconstitutional laws be arrested for violating their oath? Here's what it is. The courts have generally said they will not prescriptively deny the legislature from passing bad laws. that their approach, generally, the courts say their approach is let the legislature make its unconstitutional law, let the governor, if he's soft-headed enough, sign it into law, and then we, the courts, will take a look at what they've done and we'll decide at that point, after the bad policy has become law, whether it's lawful, constitutional, self-contradicting, all these things. So it's very difficult to stop the process. You know, if a speaker has the majority of the votes, he or she can basically run whatever cockamamie bill they want through. You hope that the governor, the executive branch, would be kind of a check on that. The governor would take a look at a bill that's patently unconstitutional and not sign it. But we don't have that right now in Washington. So what you'll get is if a bill passes into law, then the courts take over. They don't like to stop legislatures while they're messing up. They prefer to wait till later and then say they messed up.
Thank you.
Hey,
All right,
Jim,
this next.
hang on one second.
Go ahead.
I got a question for Jim here, actually. Representative Walsh. So I know I agree about the chilling effect that you would have on the, if we were arresting people for passing unconstitutional laws. But I want to ask you about legislative findings. Because, like, for example, I take a look at Senate Bill 5078. The legislature finds that the irresponsible, dangerous, and unlawful business practices by firearms industry members contributes to the illegal use of firearms and not only constitutes a public nuisance, but also exacerbates a public health crisis. Now, where does that data come from? Or do they just make, this is an open-ended question, are they just made up out of the sky? Because where does these types of, do they have data to back these findings?
No, the answer is yes. They just make it up. The intent sections of legislation are some of the worst, most political, most baseless rhetoric that there is. 5078 that you were reading from, pretty bad, but read the intent section in 1240. We actually mocked it during the floor debate on 1240 on the assault weapon ban. And rightly so. It's full of rhetoric about hyper masculinity and angry young men who become spree killers. It's absolute junk, completely politically partisan, based on nothing, and it's like an hysterical screed. We ran amendments that pointed out how badly drafted that was, and basically mocked the ridiculous language in that intent section. And it was funny to see the media cover that. One of the columnists for the Seattle Times completely missed that we were being sarcastic and ironic and mocking when we were talking about the bad language, and kind of made a fool of himself with a really badly written column that took some of the criticisms too seriously. It was something to see. But those findings, Bill, they're nonsense.
Yeah.
You know, the courts call them dicta, which is
that's what
words.
We got other words
don't necessarily
for it too,
mean anything.
We got other words for it also.
Right. So they're basically for those of you who are new to the process, these intent sections are essentially the introductions to the bills, and it's a chance for political partisans to get on their soapbox and kind of rant for a few paragraphs, and then they get into the body of the bill, which is the part that actually becomes statute.
Thank you.
Thanks, Jim. Okay, next question is from Teo Morca, and he's been very active in this session and speaking out on these, speaking in committees and testifying on these bills. And he asks, how can we begin to insist on a data-driven proof of efficacy for any of these anti-gun bills, which, if not met in a statistically meaningful way, example, the law did not have the effect on gun violence that the proponents promised, that it is effectively time-bombed and will fall off the books?
Well, lies, damn lies, and statistics. I I'm wary of a lot of the rhetoric around data-driven or evidence-based legislation. Those terms and concepts have been so corroded by the far left that I would prefer legislation to simply be constitutional and internally logical. If it can be those things, I'm willing to say that a bill may end up not doing what it meant to do, and that is never good, but that might not be the worst thing. But what we lack really in our law in this state, to some degree at the federal level, is internal logic, internal consistency. And I guess my standards are lower than yours. All I want is a bill to be internally consistent and logical. And if we do that, the trouble with saying you want evidence-based or data-based public policy is that data and the evidence is so often manipulated, it's not reliable. And Lord knows we just went through the COVID episode where science was twisted into a hideous misshapen mess, all in theory evidence-based. And let's just go for logic. Let's go for simplicity, constitutionality, and internal logic.
That would be good. All right, next question. Can you speak to the anticipated timing of Senate vote and signing of 1240, at least best guess? Well, I spoke today with the ranking member of the Senate Law and Justice Committee, and we had heard about some dates. He didn't have a best guess for me. It is in hearing, public hearing next week on the 23rd. Executive session would probably be the following week. So let's say sometime around the 30th. Bill and I had kind of geeked out a little bit on our best guess on that. And we thought maybe last night of session in the, dark hours of the night when they like to do these things. We thought that would be fun on a Saturday night to all be watching TVW.
We've done it before.
We have. Jim, what do you think?
Worth pointing out at this stage with this question, there is an emergency clause on 1240, which there is not on 1143, and I do not believe there is on 5078. I'll have to go back and look. An emergency clause says that the bill becomes law immediately upon the governor's signature. Normally in Washington, as in most states, there's a sort of phasing in period. Most standard legislation takes effect 90 days after the governor signs it into law. However, you can attach to any bill an emergency clause, which says that the policy point is of such urgency that the usual 90-day phase-in period will not take place, and the bill becomes law immediately. So the so-called assault weapon ban does have that clause on it. Part of our floor debate was we tried to remove that. It also, in this case, causes trouble for dealers, good faith dealers, who don't know how much inventory to stock because they don't know when the governor's going to sign this into law. And if it takes place immediately, they can't sell anything as soon as, they can't sell any of the prescribed models as soon as he signs it. So we've tried to get rid of the emergency clause. We tried to add a different kind of phase-in period, all rejected. This is a photo op. The governor wants this as a photo op. He will use it as a press release and try to dominate the news cycle when he signs this scud into law. And so you're geeking out about timing is well made, and I would guess he will time it so that he can catch the optimal news cycle. I don't think he would do it on a Saturday night or late in the evening because he wants maximum media coverage when he signs it. He could sit on it for a couple of days, of course.
Well, we're thinking that he signs it, or it passes on the floor on a Saturday night, and then he's got all the cameras and everything rolling on a Monday afternoon or a Tuesday afternoon when the news cycle's hot.
That's exactly what I think they'll try to do.
Amazing.
Julie, real quick on that,
Yeah.
right now I've talked to a lot of FFLs, and at this point, because you got to remember, on a semi-automatic rifle, 941092 says we got a 10 business day waiting period. So they're concerned at this point that this could get fast track signed, and now they're sitting on inventory and things like that. So I really think that you're probably, for folks who are interested in buying a completed rifle, you're down to your last 24 to 48 hours before I think FFLs are going to be at a point where they're uncomfortable doing that. Little trick: lower receivers do not fall under the purview of 941092 and do not require the 10-day waiting period. In fact, you get to take that home as soon as your background check clears. And I do know there are several FFLs that are still stocking up on those components and parts, so that may still be a thing. But Representative Walsh is right that with the emergency enactment clause in there, the minute it signs, it's it. We're done. So the time to stock up, if you're thinking about it, is now.
Interesting story on that piece, Bill. We had a bipartisan amendment that would have left the emergency clause on 1240, but allowed dealers to have a 90-day period to sell through their existing stock. It was a semantic difference mostly, but it would have given them, it left the emergency on there, but still gave them 90 days to clear inventory. And we had bipartisan buy-in on that. Even some of the anti-2A activist groups had shrugged and said, okay, we won't fight that. And the speaker decided at the last minute to toss that deal out. So we had something that would have given dealers a little more grace, a little more time to sell through their current inventory, and really just a little more clarity. I mean, that's what business people always want. They just want to understand clearly what can I do, what can I not do. There is a chance that we might be able to attach that agreement at the state Senate level, because we thought, I mean, we had all sides. We thought we had all sides agreed to it at the House level. So if we can attach that at the Senate level, that would be an improvement. The question then is, would the speaker, who clearly doesn't like that, try to strip that back out again when it came back for concurrence from the state Senate to the House? But that was a deal. And maybe it's not a dead deal yet. Maybe we can still get it.
So this next question kind of falls in line with what we're talking about here. If you purchase a frame and AR parts kit before the law is in effect, and receive it before the law is signed, will it be illegal to assemble it after the bill is signed?
No, you can do that.
Okay. Okay.
And you'll be able to do it after the federal courts throw the bill out too.
Well, that's true.
But there'll be a window of time there where you'll still be okay for building your firearm.
Yeah, and there is a lot of stuff going on the federal court level that the viewers will need to at some point be aware of, because things could change here a lot.
All right, I've got another question on Senate Bill 5078. This is from Jordan. Hello, thank you for your time this evening. Regarding the Put the FFLs Out of Business Act, I love that bill. Are there any specific guidelines that may protect the many FFLs here in Washington? A number of crimes that I've read about involve stolen firearms. Will this always come at the discretion of the AG's office? Is there any way that the FFLs that fall victim will be able to survive a lawsuit? I also want to give a big thanks from a few of us at Arrow. Your hard work and education has, I believe, managed to keep many of us in business.
Well, good for you for working at Arrow. There was some language that have been added to a couple of these bills to try to specifically allow Arrow to continue to stay in business, for now at least. So you are recognized as an important company and employer in this area. Even the left has acknowledged that, so good for you. No. I mean, the short answer is no. I mean, 5078 is a blank check for the state attorney general to go after any business that really is involved in any part of the industry. It's very poorly drafted, very overly broad. So, but that's what who wrote it? The state attorney general wrote 5078. So it's giving himself permission to, go after any of these businesses. I don't think he would go after Aero Precision because they are so identified as an important employer and a player. But he would go, look at what he's done with the magazine ban. There was a small, literally mom and pop gun shop that either being stubborn or being unaware sold some magazines, and the state attorney general went after them furiously. He's a bully. He tends to go after smaller operators, and Aero is big enough that I don't think he would go after them, but he'll go after smaller operators, smaller gunsmiths, smaller dealers.
Julie, real quick, a couple of things on that too. First of all, folks at Aero Precision, I'll see you Monday morning because I'm shooting a video down at Aero Precision because we're going to talk about the 862 jobs that the city of Lakewood has that are in jeopardy now. You know what the second largest employer is in the city of Lakewood behind Aero Precision? It's the city of Lakewood. Actually, they're the second largest employer. No, this bill is designed to put every FFL out of business. If you read the language, once the attorney general releases the attack dogs and forces you through all the discovery process and everything like that may price you out of the market, then if you are found liable on this, you can pay up to 3 times the actual damages. Okay. Here's the other thing. This bill essentially is, it would be like if somebody bought a used Ford pickup truck from a used car lot, got drunk and killed the family, and now you want to go back and sue the original Ford dealer that sold that truck to begin with. Okay, that's essentially what this bill is trying to do. Okay, and it's notwithstanding the criminal activity of third persons. And so this bill is absolutely intended to drive the FFL out of industry. I just did a video shoot at 3 Aces, a small mom and pop place over in Spokane. Last weekend, they've been told by their insurance company, and 2 other smaller FFLs were told that if 5078 becomes reality, they're not going to renew their insurance policy. And this is exactly what the attorney general wants. This is the exact effect he wants.
And that's exactly right, Bill. And one of the problems here is in his zeal to get into the newspapers by means of this blank check for phishing against gun dealers, he's going to create an awesome black market. He's going to push a lot of currently legitimate and well-regulated commerce underground, where God knows what'll happen. God knows who will end up buying firearms. It is this overzealousness. I mean, and this is an historical cycle we see, where we will get people who do this kind of thing. Think about, prohibition. When you ban too much stuff, you create illegality, you create black markets. And my fear is if 5078 becomes law, even for a short period, this attorney general is going to create a black market, an illegal underground economy of firearms that will be far more dangerous than any semi-automatic rifle.
I think they know that too. All right, next question. Bill, I'm going to pitch you another question from Jordan over at Aero.
Oh, yeah. Okay.
Aero love.
All right.
Would you be able to share your thoughts on a time frame in which 1240 could be overturned following its passage, given the many laws that are likely to be overturned, such as in California? Will these determinations across the nation have an impact on us and our ability to exercise our rights?
Yes, great question. Great question. There is a lot happening at the federal court level, and there could be big news happening while House Bill 1240 is kicking around in the Senate. And that would be an interesting thing to happen. As we know, there are 2 big cases. There's technically 5 cases right now that all the briefs are in, the arguments are done. We're just waiting for rulings. The 2 cases that we would be most concerned about here in Washington, one's called Miller v. Bonta, the other one's called Duncan v. Bonta. Both of them one deals with magazine ban. Sound familiar? The other one deals with an assault weapon ban. both out of California. In one of those two cases, the district court has already ruled in favor of the plaintiffs, found the law to be unconstitutional. It ricocheted its way on up through the Ninth Circuit and eventually was sitting on the doorstep of the United States Supreme Court when the Bruin decision was announced. And so it was kicked all the way back down to Judge Benitez, who has been told to rewrite the opinion, but we already know what his opinion is. We also know that Judge Benitez has authored for a number of years a one-part test analysis. And so in many ways, he was very clairvoyant because he authored an opinion that was consistent with what Justice Thomas wrote later. We're anticipating a ruling on those cases at any moment. Any moment. In fact, I just did a video on my channel today, which I described how I believe Gavin Newsom and Rob Bonta are about to get carpet bombed by the court system down there, because I do believe that we'll have a ruling out of Judge Benitez that says assault weapon bans are per se unconstitutional, as are magazine restrictions. The plaintiffs will immediately move for an injunction to cease the enforcement of that law. That will force California to have to appeal it. They will appeal immediately to the Ninth Circuit. This is where it gets really interesting, because the great escape hatch that the Ninth Circuit and all these other courts had to get out of this thing with that two-part balancing test has now been welded shut by Bruin. And so if the Ninth Circuit takes that appeal and follows the law, they will affirm the lower court. And once they affirm the lower court, that's the law of the land in the Ninth Circuit. Because the state of California could try to appeal to the United States Supreme Court, they will not accept review. If the Ninth Circuit were to structure some kind of a ruling where they overturned and actually still upheld those bans, I can assure you that the United States Supreme Court would accept review on that instantly. So all of this, as far as with the Ninth Circuit, could be resolved by summertime. And we're going to get a ruling out of Benitez before the end of this month. I really do believe that. We may get a ruling out of Benitez on the assault weapon ban while it's still kicking around in the Washington State Senate. And it will be very, very interesting to see what those state senators do, knowing that there is a ruling in their circuit court that says this is per se unconstitutional. So do I believe that any of this is, we're in for this for the long haul? No, I don't. I am encouraged by the case law. But do I think we got some short-time suffering to go through? Yeah, unfortunately, I think we do.
For those of you who aren't attorneys and practitioners, Rob Bonta is the state attorney general in California, and very politically tight at the hip with Governor Newsom down there.
That sound familiar at all?
Yeah, very similar dynamic to what we have here in Washington,
right,
with Inslee and Ferguson, our state attorney general. And for those of you really who don't follow this stuff closely, remember California, Oregon, and Washington, plus Alaska and Hawaii, are part of a federal circuit. And we all basically have to follow the federal court circuit there. There are immediate kind of wise men and women who decide what policy can be. Now, the federal circuits are appeals courts. They have to follow the instructions of the U.S. Supreme Court. And these cases that Bill mentioned out of California are the ones that will apply this Bruin decision from the U.S. Supreme Court to the more local level here on the West Coast. And what those judges in California, federal judges in California, rule about the federal law will stand for us here in Washington, because we're part of the same circuit. Judge Benitez down there is a hopeful sign. Some of the rulings that judges made have been fair and therefore favorable to guns.
Thanks, Jim. I know a lot of people here are probably a little bit like me, and a lot of what Bill says is like, whoosh.
Oh
man. All right, let's keep moving here. We're 8:25. I'm going to take a couple more questions. There's a lot of questions. And so what I'm going to do, just to let everybody know, is I'm going to take all these, we'll compose all these, and then I'll send them off to Bill, and I don't know if Jim even has a chance to read his email, but I know these might be good content for upcoming videos on the Washington Gun Law YouTube channel. Subscribe over there if you're not already. Let's take a question from William Anderson, which also happens to be my dad's name, but I don't think this is my dad. Are the proponents of this bill arguing that an interest balancing analysis is applicable to Article 1, Section 24 I struggle to see how this can be reconciled with the plain text of our state constitution, which in my opinion would explicitly protect access to modern firearms.
All right.
No, they don't rationalize a balancing test at all. They don't operate at that level. That's far more sophisticated than where they operate. Where they operate is guns bad, hurt children, vote to strict guns, no more guns, guns bad. I'm serious. There's no sophistication about balancing acts at all. If you listen to any of the floor debate, the arguments pro on these bills, first of all, are not made very much at all.
No.
And to the extent they are made, it's tearful personal stories. My daughter was terrified that there was a lockdown at her school. Please ban all guns. It's completely emotional. There's no logic. There's no legal sophistication at all.
The balancing test is really once you get it into the court system and things like that. So what a lot of those state legislators, if you look around in New York, New Jersey, California, Oregon, all the other states that are doing this stuff, there's dicta in the Bruin opinion where the justices threw some cautionary to the wind, where it was like, hey, listen, we're not saying that all gun restrictions are per se unconstitutional. There's obviously some sorts of regulations that we need. They didn't enunciate or go into detail because we weren't really worried about that. They have taken those few words in hundreds of pages of opinions and said, well, there you go. So, you know, some gun restrictions are reasonable, like the ones we're proposing.
I want to take this opportunity to let you all know that you should watch a floor debate, or you should watch a committee hearing and watch the public testimony that you see in these hearings, and watch the debate that happens on the House or the Senate floor. It's infuriating, to be honest. But it will really enlighten you. And, you know, one of the things that we have been trying to do between, I think, the three of us this session is trying to get citizens engaged in this process, and to know that, you know, you don't have to have any special credentials to go and testify in one of these hearings. You just have to be a concerned citizen. You don't have to, you know, have anything profound to say, but you just have to go in and defend your rights and tell them why you want that or don't want that. And so I would encourage you, and we try to put out on our social media channels when something's happening live, we try to push it out so that you can click on the TVW link and go tune in and watch it as it's happening. You can also go and watch replays of all of this stuff, but it's a great learning experience. If you haven't watched it, I highly recommend it. You could do have some kind of drinking game going on with it whenever they say, you know, gun violence or assault weapons, whatever your words of choice are going to be. But it's something that I encourage everyone to do. In all transparency, I don't think I watched any of this stuff until the tail end of 2021. So I'm new here, just like a lot of people are this session. We're all kind of waking up with all of this bad stuff that's going on. So just wanted to put my little plug in there to get active and get involved. Let's see, I'm going to take 2 more questions. Is that good with you guys? Do you guys have time for 2 more? Okay. Elizabeth is asking, does 5078 section 2 line 34 concealability include holster manufacturers? What about manufacturers of 3D printers or CNC machines, line 37? All
right. Jim, you probably know the bill by heart, so why don't you go? No, I've talked to some people about that, and this is what Representative Walsh talks about. When gun bills are written by people who don't have a clue what they're talking about, they come up with language that can be incredibly overly broad. Do I believe that their intent was to ban the sale of holsters in this state? I do not. As nefarious as I think some of them are, I don't think they're, but Jim, you can correct me on that, okay? Does it arguably include that when you look at the language of the bill? Yes, it does. Yes, it does. Do I think we're going to see an end of sale of holsters? No, I don't.
It would have to be, Bill's right. Exactly right in point there. I don't believe it was the intent, but it is the poorly drafted language. Someone would have to test it. So, I think holster manufacturers we'll keep selling holsters, and someone would have to test it. And I think the bad policy, the whole bill, will probably be disposed of before the dispute would get to that level. But it's a risk. It's a risk in the poor drafting of the bill. The anti-gun people are almost obsessed with this idea of 3D printing guns, and you can do that actually, but they are convinced that that all the bad people are going to 3D print guns, and they've tried to restrict that primarily with another bill that was passed last year, a so-called ghost gun ban, and then some language in this one too. But again, their lack of knowledge of the mechanics and the actual truth of how you would use 3D printing to make a firearm renders the bills that they produce kind of gibberish. And but they'll continue. You'll hear them talk about the 3D printed guns, and they've got to stop that. They've got to stop that.
A quick question, and I don't want to spend too much time on this before we get to our last question, but who's going to enforce all of these laws?
Well, that's an interesting question, isn't it? Because if you go talk to some of the sheriffs in this state, it probably is not going to be their departments. I had the great pleasure 2 weeks ago being down in Klickitat County with Sheriff Bob Songer, fantastic gentleman. And then last week I was both in Lincoln County and Spokane County with their sheriffs at some educational events, and they firmly believe that these laws are unconstitutional. They take their job very serious, which is number one, keep the community safe. Number two, protect the rights of their citizens. And they take both of those roles very equally as important. And what I'm getting from those particular sheriffs, and they're very loud and proud about it, is they have no intention of enforcing those laws. Now, they're the sheriff's departments. You have local municipal police departments. You have the state patrol. I think there's a lot of troopers in the state patrol that personally are very opposed to this, but the state patrol is a very good law enforcement agency and has a tendency to play it by the book. That's what makes them a good law enforcement agency.
They report to the governor as well, don't they?
Yeah, and listen, as a criminal defense attorney spending 20 plus years in the courtroom dealing with a lot of law enforcement agencies, the state patrol is a really good law enforcement agency. It is. And the citizens of Washington State should be pleased with the Washington State Patrol. They do a good job.
Good to know. All right, final question. And I get this question a lot. Y'all probably would not believe how many people message me on the daily. Hey, could you ask Bill this question? Hey, could you ask Jim this question? So it's nice to have us all in one room and people can ask themselves. So could shipping companies who deliver things like ammunition be affected by 5078? Could this cause problem for people getting parts and ammo delivered to their home?
A short answer, yes. This topic came up. Again, I don't believe it was the intent of the bill, but the overly broad language in it suggests that, yeah, that could happen. I believe if anyone tried to, now remember, 5078 enforcement wise is different than the other two. The enforcement mechanism in 5078 is not your sheriff or your local police department, it's the state attorney general.
Right.
So if the attorney general decided to go after a delivery company, I think the delivery companies would be pretty successful pretty quickly in getting a court to see that they were not the intended object of the legislation. But again, that would require court action. And kind of like the holster question, I suspect that 5078 will be, either enforced or not enforced or tossed out entirely on bigger questions than those. I think it's going to face a challenge right away. And to some of what Bill said before, I think active parties on all three of these bills, if they become law, will be looking for injunctions. That is, quick decisions from the courts to hold the questionable law pending a ruling from the court on its constitutionality. And I wouldn't be surprised if those injunctions are awarded.
Bill, did you have anything to add to that?
I think that when you see any of these bills become reality, especially with 1240, I would say that the moment Governor Inslee signs it, you will probably have lawyers in about 4 or 5 courthouses waiting, and the suits will file within a minute. I think that you will see suits in both the Eastern and Western District, Washington. You'll probably see one routinely. There's one filed in Thurston County Superior Court. I think where you're going to see the most leg is, and I'll leave this up to the people that are going to be doing this, but a suit for an injunction in Chelan County, Yakima County, place like that, where you're going to have a pretty favorable venue, I think could be really, really successful quick. So I'm sure you'll see something in one of those counties. Klickitat County might be a good county too, now that I've been there.
Thank you so much, gentlemen. Before we sign off for the evening, we do have these bills are not law yet. So Jim, talk to us about what can people do now. We had a hearing in your Civil Rights and Judiciary Committee yesterday morning, and there are 3 of us on here tonight that were signed up to testify that did not get to testify. We sat there for 2 hours. And then I know you've got executive session on those bills, which is 5078 and 5006. Tell us, what can we do?
Well, we just got word today that 5078 will not be voted out of committee tomorrow as originally scheduled. That probably means that it'll be voted on next Friday. We tend to vote bills out of committee in the Judiciary Committee in the House on Fridays of each week. So that was an interesting development. I'd like to say it was a hopeful development, but my fear is they're trying to concoct a way to put that private right of action back into 5078 at the committee level before it gets to the floor of the House. Remember, everybody, that just like in DC, bills switch chambers at the halfway point of the session. So the 2 bills, 1240, the so-called assault weapon ban, and 1143, the class to exercise your right bill, started in the House. They are now in the state Senate. So you still have time in Washington to contact your state senators or all the state senators and express your concerns about House Bill 1240 and House Bill 1143. As we were just saying at the start here, the Senate bill, the one of the 3 that started in the state Senate, 5078, is still in the House. So that's true. You can contact your House member locally where you are, or you can get the list of all of them and email or call all of them and say that you have concerns about 5078. You don't think it's constitutional. You don't think it should be passed into law. You can also just stay active, share information, whether it's on social media or in real world with neighbors and friends about these bills, and just keep yourself informed about where they are. The legislative session ends in late April, early May, probably late April if things go on time. And you have till then to keep your eye on what's going on here with these bills.
And we will. I put the link to our Legislative Action Center in the chat. If you aren't already following that, we update these calls to action on these bills as they move around, because as they're moving, you need to contact different people. So you can always find the latest there on our Action Center. And Bill has been doing daily videos on what's going on with these bills and all the breaking news. So be sure, if you're not already subscribed to Washington Gun Law on YouTube, head over there. Social media, especially Twitter, I think is where all 3 of us are most active. So you can follow Jim Walsh, LD19, I think it is, and Bill is at Gun Washington, and we are CL of Washington, and I'm Julie C. Barrett, but we're all tweeting out a lot of information. I think we're all on Facebook as well. So those are great ways to stay active. Conservative Ladies of Washington, we have a legislative action team that meets every Monday night where we strategize, and people are researching different bills, and people are signing up to testify for different things. And we're kind of making sure that we're covering some of our top bills. We don't just do 2A bills, we do a lot of different things. So if you're interested in that, consider joining us, become a member. You can do that over at conservativeladiesofwa.com. And we will keep bringing you the latest. Jim, again, I can't thank you enough. You are just a treasure of Washington State. And I know I speak for everybody here. You are amazing, and we are grateful for you being in this fight. And every time I watch you on the floor, amendment after amendment after amendment, I appreciate you. And I know I speak for everybody who's watching tonight as well. And Bill, it's an honor to be in this fight with you. We make a great team, tag teaming on all of this stuff.
We do.
So, and we will keep doing it, guys. We'll keep bringing you the latest. So don't give up the fight. We're just going to keep fighting till the bitter end. So hang in there. Thank you, gentlemen. Thanks, everyone, for joining us tonight. And
We're going to win, Julie.
that's right,
We're gonna
Jim. We are. Light always wins. All right. Good night, everybody.
Stay safe, everyone.